Okay, we're now on the record. This is the Kentucky Public Service Commission. My name is Michael Schmidt. I'm chairman of the commission. Seated to my right is Vice Chairman Robert Cicero, and to my left, Dr. Talina Matthews. Purpose of the formal conference this morning is to discuss case number 2020-0012, purchase gas adjustment filing of Navitas, Kentucky, NG, LLC. The purpose of this hearing is to discuss on the record the gas cost adjustment calculation, the methodology, and report structure. This conference is on the record. There will be a log completed, and the video will constitute the official record on the proceeding. It is not being transmitted live over the internet, so there won't be any other people watching it other than they can check it out or get to view the video at some later date. At this time, would counsel for Navitas please identify herself along with her client?
Allison Honecker with Goss Sanford. I'm here on behalf of Navitas KY NG LLC, and with me I have Thomas Hartline. I filed a written entry of appearance this morning to the record for this case.
And for staff?
Andrew Bowker for Commission Staff Attorney, Sarah Jankowski, financial analyst, and Leah Faulkner, financial analyst consultant.
Hey, good morning, Ms. Faulkner. It's always good to see you
Good morning.
back again.
Likewise.
All right, I guess to proceed, the best way to begin is for staff to, set out the reasons for this conference and what we hope to achieve by it and what needs to be discussed. Okay? I don't know what counsel, whether that will be Mr. Bowker, whether that will be you or Ms. Jankowski.
We are here to discuss 2020-00012. We have a couple concerns regarding Navitas's GCR report proceedings, a couple of issues involving the calculation, continuous spreadsheet error, and just general questions on the implementation of the FERC transportation rate in the GCR rate report.
Okay. Well, you may proceed and how you would like to move forward.
I'm going to ask Mr. Thomas Hartline a couple of questions. I'm going to start general. Can you walk me through the initial GCR report process for Navitas?
Certainly.
Can you do that? Do you want him to pull it up, his Excel
If
spreadsheet?
it helps.
Yeah, that would be fine.
Can you do the presenting part?
So just to give you a little background, when we purchased the Albany system out of bankruptcy about 10 years ago now, maybe not quite 10 years ago, that was our first system here and continues to be our only system here in Kentucky, although we've since built onto that system pretty extensively. So at that time we came in and Kentucky, we're in 4 states. We're in Oklahoma, Texas, Tennessee, and Kentucky. And Kentucky was the only state that has a prescribed GCA process where they had sheets that you filled out to turn in your GCA, whereas the other states just allowed you to develop your own program. What we did is we took the Kentucky program and we ended up liking it so much we put it on an Excel spreadsheet, and then we have since adopted that to the other states. So this is the same model we use in Oklahoma and Texas. We use a modified model of this in Tennessee because they only allow submission once a year, so it's a little bit different there. But as I said, we took your model that we liked so much and adopted it and use it in our other states. So the sheets that are represented on the in the spreadsheet were the sheets that, these are like the sheet numbers and the sheet titles are the same as what was in the Kentucky system that was given to us when we first came in. So just very simply, it starts with a cover page. We submit 4 times a year. This details which months are the reporting months, which in this instance it's August, September, and October. It details when it is being filed and when it normally would be implemented. The summary page is just that, a summary of the various components, the total here at the top, and then you have the 4 components, which are the expected gas cost, the refund adjustment, the actual adjustment, and the balance adjustment. The refund adjustment is almost never used. I believe we've only used it in one instance, and I don't think that was in Kentucky. I think it was in another location. But be that as it may, you almost never have to use the refund adjustment. The expected gas cost is just that. It's an estimate of what you think gas is going to cost going forward. And this is just based on discussions with suppliers, what you know your transport costs to be, and I actually have a question here. I'm not sure are we required to use the last 12 months usage, or are we allowed to use, if we think our usage is going to change, are we allowed to use a projection of usage? And so that is an open question that we have. And the reason it's an open question is I actually get confused because I think Oklahoma requires you to use either the last 12 months or the average of the last 3 years. It gets a little confusing. So that's an open question for you, what I'm supposed to use there exactly.
So could I interrupt for 1 second?
Uh-huh.
You say it's an open question, but have you contacted staff and asked them this open question for determination?
Well, that's another interesting thing. It doesn't seem like I'm allowed to talk to staff.
I don't quite understand. When you say you're not allowed to talk to staff, who would you speak to at the commission if you didn't speak to the staff?
I don't know. That's what's confusing to me. Like, I don't know who I would call, and I don't know if they're allowed to talk to me.
Have you ever spoken with Ms. Jankowski or emailed or had any communication with anybody else?
I think we've tried to email some questions before, and then we're told, and it actually in the last order that came out, it said specifically that the commission only communicates by written order.
So I'm sure Ms. Honecker could elaborate on that, but knowing that she has just been retained by you and probably hasn't had an opportunity, the commission speaks through its orders in order to rule or give its direction to the utilities. But in the interim period, when a case is being developed or there is an issue before the commission, the staff generally acts as the resource for utilities to go to in order to clarify potential issues like what you're speaking to, because especially in a gas cost adjustment case, it's, as you've indicated, and you're utilizing the Kentucky spreadsheet in your other operations, it's a pretty standard every quarter type of adjustment that staff would be evaluating whether the information provided is accurate or inaccurate, and if the guidelines that are directed towards utilities in order to fill out the spreadsheet are being followed the way they're supposed to. And I think that's one of the reasons why we're having a formal conference, is to, if there's this misunderstanding or there's some kind of direction that needs to be given. This is a formal conference, but it's obviously not a formal hearing. I think you'll get all the direction you need. And if there's questions, staff is always available to answer questions.
Okay,
Okay.
that's great. I appreciate that. That'll make it easier, for sure.
I'll make it easier on them too, because that's what they're looking for is consistency.
Right.
I mean, have you ever, you or anybody on your behalf, ever tried to contact staff by telephone and told that they wouldn't speak to you or wouldn't provide information?
We might have a misunderstanding as to when a case is, so for example, one of the things I wanted to talk about today when I initially made contact was something we're going to be doing before we file it. And one of the impressions we had is once we file something and there's a case number that we can't talk to, we can't talk on the phone to staff, or if something has a case number assigned. Maybe I'm misunderstanding this completely. By the look on your face, I'm getting the sense that I'm misunderstanding this completely.
Yes.
Once a case number is always established, and there's not, that just means that the document has been recorded and established in some kind of a data going forward is assigned into that case. It's not then a blockage that says you can no longer speak to anybody at the commission about it, because that's all. Even an application for a general rate increase, utility files are assigned a case number, and from then, everything builds forward from that process, and there can be data requests the commission issues, the staff, they would be in contact with the utility in order to clarify. So establishing a case number only provides a reference for you when you're going to speak with staff that would say, I'm calling about case number 202000012. There seems to be issues on how we're filing. What are we doing wrong and how do we correct it? There's no problem with contacting commission staff.
Right, okay. Well,
It's never potentially adversarial until it gets to this point.
right, right. Okay.
We'll discuss that after.
Okay.
So in any case, on the expected gas cost, it's just a projection of what you think gas is going to cost. Now there is an open question, and I'm going to move on from that. It has to do with the B&W issue, but I'll come to speak to that here on this next tab probably. So but just to kind of complete the idea, the expected gas cost, this is the cost that's going to be implemented, as I discussed. This would have been implemented on February 1st. Now, it wasn't in this instance, but that's normally what would happen is whatever you say the expected gas cost is, that's the number that would be implemented prospectively. And so, for example, if we go back to the summary on this, you can see that here we've established the expected gas cost at $7 an MCF. Now, the actual adjustment is, remember I talked about the reporting months on the cover page. So we're reporting August, September, and October. So if you look at the actual adjustment, here we have August, September, and October, and these were the actual costs we had incurred for the month. And then here, this number here, the $6, that was the expected gas cost that was in effect at the time of those months. So as I mentioned, on February 1st, the expected gas cost prospectively was going to be $7. At the time that these months occurred, the expected gas cost in effect was $6. So,
Mr. Hartline, may I interrupt for a second?
sure,
One of the issues is that actually that $6 was not approved by the commission.
okay.
I just wanted to point it out that you have implemented the $6 that you had in your report, but not the actual EGC approved by the commission.
Okay.
So when you were speaking to the order that the commission issues, in the case of a gas cost adjustment, the final order would come out with approving all the rates that the commission approves, and then those would be the rates that you would use for the spreadsheet going forward. And I think what Ms. Jankowski is talking about is the fact that you've come up and developed a rate, and the commission reviewed it and didn't accept that rate and said, this is the rate that you should be using. So you've been directed to use a rate through an order, but you're not using that rate. Is that correct?
Yes.
So you have to, while that may have been your forecast, after the commission reviews your rates for what it would call reasonableness, because I understand there's forecasts, you use NYMEX, there's different areas to develop some kind of a purchase price. But then the commission has to go back through it and say it's reasonable or unreasonable. If they consider it unreasonable and establish a different rate, that is the rate you should be using in your spreadsheet going forward. So that's probably where part of and again, you can speak to staff, you understand you're able to speak to staff now.
Right.
That would be something, if you communicated that they would advise you, is how the process worked.
Okay. So one question that'll come up is we'll have to look to see what we actually charged. So I don't know. I'll have to look back at our PGA or GCA to see and compare it to the order to see where we're at here.
Why wouldn't you have done that when the order came out? Where would you get it? As a regulated entity, where would you have gotten a number to charge that was not the number that was in the order?
Without having everything in front of me,
This is a theoretical, this is not a, what spreadsheet, Why
I
are
don't-
you using rates that aren't in the order from the commission that
I don't
regulates
recall
you?
seeing an order that changed the expected gas cost.
Okay.
I believe what you used was what you had proposed, right, was your calculation?
That's
That's
correct.
where the 6 came from.
Sorry.
In any case, this lays out, so you have your actual costs, you have the expected gas costs that you charge, and you're going to either, it would be very rare that those numbers would actually match, right? So there's going to be some delta. And in this instance, the delta was, we undercharged customers $81,000 for the quarter, which ended up being, now this is another, I think by statute, I'm not sure, we're supposed to use our last 12 months. My understanding now is that we are supposed to use our last 12 months usage as the divisor. We used our average usage, and I can kind of explain that. If you look at our sales, especially over the last 6 years, if you look, you can see there's a huge volatility in the sales. And you can see here where we were selling around 30,000 MCF a year, and then it went up quite significantly. And that's where we were able to bring on we built a pipeline to a chicken processing facility, and we were able to bring on that chicken processing facility. But that chicken processing facility has the ability to switch between retail propane and natural gas on a daily or hourly basis. They whatever's cheapest for them is what they use. And so you can see that we've had some pretty significant volatility based on the price of natural gas versus the price of retail propane. And so while our last 12 months usage was 113,000, because the increase from the FERC rate on the B&W pipeline, we anticipate that our sales are going to drop off pretty substantially, because we'll be over the cost of retail propane. So that's why we had used a average sales number as the divisor. But be that as it may, one of the important things to note in this recovery, so another thing I should point out is that this 82 cents is pretty, you can see there's some volatility. And in the past, our actual adjustments were really small. They were less than 10 cents. But since we've kind of had this issue with the B&W and trying to figure out what all that means, our volatility on our actual adjustment has increased quite substantially. What happens with this actual adjustment is it gets paid, either paid to the customer or paid back to the company over a 12-month period. And it's paid back, of course, prospectively, or paid to the company or paid back to the customer prospectively. And initially, you can see that it totals, it shows that it's going to get paid back exactly to zero. But in reality, that never happens. That it always, there's some residual amount. So for instance, you can see here, right here on this one, this was, each of these actual adjustments layer. So there's 4 of them, one for each quarter. So one is dropping off and one is coming on. And so they layer, and then at the end of the actual adjustment, you can see on this one, there was a delta of $643. So in this particular instance, we over-collected $643, and the process happens again, where you take that $643 and you divide it by 12 months sales, and that becomes your balance adjustment. And there's 4 of those. And they layer in. One's dropping off and one's coming on. And so they layer in. And so at the end of your balance adjustment, you're very close to a zero number. I mean, there's always some small residual number, but then that gets put back into the next balance adjustment. So for example, there's one that's $42 there. Or $43.29, excuse me. But in any case, the important thing to take away from that is, if in the actual adjustment we've over collected from our customers $81,000, we will refund exactly $81,000 to our customers. Regardless of what the sales ultimately end up being. Eventually, you will either collect or refund, whichever the case may be, the actual exact number that has been over or under collected.
So are you making an argument that the commission should change the methodology to be an average rather than an actual? Because I understand what you're saying is that, and it's working the way it's supposed to, is that as you drop off on this rolling 4 period plus or minus over or under collected, it's doing what it's supposed to. It's eventually getting to the point where it's almost zero. That would be the purpose of the calculation, right?
Right, right.
So your volatility that you're expressing on whether you're higher sales or lower sales, depending on this chicken farmer, you want to use an average because you think that the volume is going to change dramatically. You're not sure. It depends on the price of gas and the price of propane, where if you are making the argument it doesn't make any difference either way, and the commission has adopted a program where it's the actual sales, why do you think it's better that you go to the average? And by your own argument, it's going to come out
Sure.
in the end
Sure.
basically at zero.
I actually wasn't necessarily making an argument for a change. I was perhaps unaware that we are required to use the last 12 months in that particular, in that slot. If that's the requirement, it's
Okay, all right.
it's perfectly
I was curious
fine.
if you were.
Now, so I've walked you through the spreadsheet that there's a particular, if I was here to make any argument at all, it is that what we've been ordered to do at this point is refund an amount of money, $25,000, based on the, I believe, based on the idea that we're going to over-collect this $81,000 by $25,000, or some number close to that. But as I pointed out here, we will only get this $81,000. We won't, even if sales went up dramatically, which let's say sales went up dramatically, and we over collected on some of our actual adjustments, that over collection would have to be given back in the subsequent balance adjustment. So it always kind of comes out to the correct number. But if we were to implement a refund adjustment based on a prospective over collection, we would actually end up giving that money back twice. So if we refund $25,000, the only way to make this come out would actually be to come in here and increase this $81,000 by $25,000. Otherwise, we'd ultimately, because this number is going to come out to zero, as I've mentioned. This is kind of, it's a fairly elegant solution, I think, that Kentucky had originally come up with, but it is a little cumbersome to try to explain, and we had to, I remember when we convinced Oklahoma that this was the right way to do it, it took some work to kind of walk them through the spreadsheet and show them. And so I understand that this seems rather clunky and like a lot of math and whatnot, but it actually is. I mean, I would hand it to you that this system you've been using since before we were here is very, I mean, it comes out right. And one of the things it does, one of the problems we experienced in Oklahoma that this addressed was that they call it pancaking there, but it's this idea that you get off by either your customer owes you a lot of money or you owe your customer a lot of money, and then the time frame to return that gets spread out. And in particular in Oklahoma, we had this situation where we were collecting kind of unbilled revenue over like a 3-year period. And what they pointed out is, look, that's not fair because maybe the customers coming in year 2 weren't there when this all occurred. And this system ensures that the bulk of the bulk of any overage or underage is collected within 1 year. Now, there's another residual amount that is collected over the 2nd year, but it's a much smaller amount, relatively speaking. So
is your, see if I can understand it this time. So is your main concern that you've developed a number that comes out to be $81,000, but there's a $25,000 piece of it that's related to this dispute on whether it's a FERC interstate or intrastate rate, and that is being set up into the refund portion, and you're believing that you would be refunding twice?
I think that's mostly correct. I don't know that the FERC issue is particular. The cause of it doesn't really isn't the FERC and this are not necessarily tied, but you do have the description correct.
So help us out here.
So the refund that you were referencing to, the $25,877, you're talking about that refund.
Mm-hmm.
So that refund was calculated based off your MCF sales and the rate that you were allowed to charge from the interim. If you remember, in 19241, we issued an interim rate, and we basically took your application for the FERC rate because it was highest, and we knew that you needed to over-collect because if it was under-collecting, it might have hurt your sales or it might have infected customers during the winter months. So we allowed you to over-collect during that period, subject to refund. So when the commission issued a final order, we would go back and we would look at your application and we would correct it and make adjustments as needed, if it was the TRA rate or if it was the FERC rate, and then we would either, set that now subject to refund. So what we ended up doing was we allowed and approved the FERC rate going forward, but we went back to your application, and in the interim rate, we accepted it as is, but we went back to it and made corrections to the spreadsheet, and that's the rate where we compared against the rate you should have charged during that August cycle, and then we found out what, based off your MCF sales, what you have over-collected. And then I think there's some misunderstanding, but based off the final order, and I believe this is 20-12, correct?
Yes.
Based on the final order, you're supposed to add that refund, subtract that amount, that $25,000, from the monthly cost difference that you got there. That's how you issue the refund. And it's stated in the final order, where we say, due to the actual adjustment in case 2012 or 20-12, truing up the actual cost of gas for usage in August, September, October 2019, the Commission finds that the amount for recovery should be included as a separate line item on the actual adjustment schedule and should be subtracted from the amount to any actual adjusted calculated in that case. So I'm not exactly sure how you perceived that, but in the order we stated that the 81K, or the amount that is the monthly cost difference, would subtract the over-collection.
Instead of adding it to that 81,000, he should subtract it.
Yes, it's to be subtracted.
Okay.
So that would take care of the duplication of the refund, but I think the difference is in a matter of timing. Then under the refund adjustment, it happens over a faster period of time, is that right?
You mean?
The refund adjustment of the $25,000, no, it's over the same period of time?
It should be over the same period.
So it's really, there's no, it's how you're reflecting it.
Right, okay. So I think your point is well taken, that if we talk on the phone, it'd probably avoid this. But while we're here, I'd like to take the opportunity to give you an update on the FERC issue that you talked about and what we've somewhat discovered. So just to, I don't know how much information you have on the FERC matter. in June of 2019, we were informed, we were given a $593,000 invoice from B&W for arrearage on a FERC-issued tariff. Now, I'd like to point out for the record that there was some discussion that we were notified and we failed to intervene in the FERC rate case. That is, I think that doesn't quite actually reflect what really happened. What B&W was ordered by the TRA to go get a 30.813 cent rate from FERC. They actually filed for a 30.813 cent rate from FERC. They notified our Tennessee council that they filed for that rate. We're like, well, they're doing what they're ordered to do. There's no need for us to intervene. Our naivete was that, when you're ordered to, my failures notwithstanding on some of what we've shown here, generally speaking, we assume that you're supposed to do what you're ordered to do. Your point, Ms. Matthews, is well taken. That no need to berate me further. But in any case, they filed as they were ordered to do. The day they got approval for the 30.813, our understanding is the day they got approval for it, they immediately refiled for a $2.72 rate. They never implemented the 30.813 cent rate. They again notified our Tennessee council, but he again just assumed that, this is part of this other deal. They never notified our Kentucky council, and this only affects Kentucky. It doesn't affect Tennessee. Moreover, there's no, in any case, they then got the rate, and they got it made retroactive, which it's like, I've never, ever, ever heard of a retroactive rate. But nonetheless, FERC issued it. Now, the interesting thing was, we asked, there was still a window, so we asked for them to reopen the case and reconsider it. They turned us down. But in the turning down, they issued a clarification. But the weird thing was, no one asked a question. It's like, well, you're issuing a clarification to a question that no one asked. So what does this clarification mean? And it's kind of cryptic. I don't have it in front of me. But ultimately, what it looks like to us is that the tariff only applies to gas that we own. So we get gas from the Enbridge Spectra East Tennessee line. We put it into the B&W line, and we transport it. And from what we can see from the FERC order is that the gas that we have title to, that we put into their pipeline, and then ultimately bring into Kentucky, that yes, that gas gets this tariff rate. But we also buy gas from B&W's affiliates that produce gas along the line. And our argument is that we don't pay the transport on that because we don't own that gas until it enters our system. So that the arrearage should not apply to that gas because it wasn't ours. We weren't transporting it, they were. Now, going forward, obviously they can just increase the price of gas to account for the transport. We understand that. But in the matter of the arrearage, it actually comes into play. Now, one of the reasons we didn't intervene in the FERC case is it is crazy money to hire a FERC attorney. So we hired a FERC attorney to, when this kind of all happened, our first bill was $20,000. We can't afford that. I mean, it's just, they're $1,000 an hour attorney, and it's just, it's just like, yeah, this is not something we can pursue. And so, we still don't know what the meaning of the clarification was, and whether or not our argument about who's transporting the gas with regard to the arrearage, we don't know the answer to that question. I suppose that we could ask FERC for a further clarification if they would make one. I don't know if they would or not. They might just tell us to pound sand.
Unfortunately, we don't know what they would tell you either.
Right. So that's the FERC issue. Now, if you'll indulge me just a little bit further, now this is something that's prospective, so it's something we plan on doing, but it has to do with this particular issue, and that is that what our intent is to build another pipeline. So right now we only have one source of supply, and that comes through the B&W pipeline. And this has been a problem for a very long time, and it's actually kind of a problem beside the point of the B&W FERC issue. We have curtailment in the winter. We don't have enough gas, so we end up having to shut off both the Keystone chicken processing facility as well as a feed mill in Albany itself end up being curtailed in the winter months. And moreover, by building this 12-mile pipeline that we're proposing to do between the end of our system and the Burkesville system, not only does it give us a second source of supply, it also gives Burkesville a second source of supply. Because, you may recall that New Year's Day 2019, the city of Burkesville was without gas because of a blowout on the Apache pipeline. And so, in this instance, by building this pipeline, not only does it give us a second source of supply, but in emergencies, we could flow gas the other direction and supply the city of Burkesville if they ended up having an issue. So, in the coming weeks, we're going to be filing two.
Pardon me. Because this is a matter that can come before the commission, I think we should not continue this discussion at this time. We don't know who else might be involved, and I think we should get back to the GCA matter to the extent possible. I wanted to offer that up.
And is that something that maybe we could just have like an informal IC with staff if there's issues he wants to discuss with
That's probably
CPN and not do it in front of the commission?
Especially having a discussion when it's on the record. Somebody might want to look at it, right? So, insofar as what we're here about, are you satisfied we have this?
I
Mr.
have a
Yankowski?
few more questions
Okay.
for Mr. Hartline, if that's okay.
Why don't we go ahead then and pursue that line?
All right, so Mr. Hartline, you discussed the GCR report in its entirety, but can you tell me are you the one who updates it for the quarterly reports?
Yes, ma'am.
Do you have anyone else who might do it as well? I know I've spoken to a Joseph Irwin before.
Our Roberto Miranda inputs a lot of the data. He's an accountant in our office, and Joe Irwin does file it, Um, uh, But I'm the one who does most of the actual work on the spreadsheet, if you will.
So, I'm very familiar with the spreadsheet. So when you create a new quarter, you just copy, paste the information, and then change the necessary cells, is that correct?
Yes, yes.
Okay, and you said that Joseph files it?
Yes, although going forward, Allison is going to help us out there.
Noted.
We've had some other issues with regard to filing and that sort of thing. We got a lot of issues. I apologize.
Just for my clarification, you have spoken with somebody
Yes,
on their staff?
yes.
So apparently there is some communication that has occurred between Navitas and your staff, or commission staff. So apparently there's some line of communication, it's just that they aren't including you.
I would like to, I have actually spoken through email and phone with Thomas Hartland
Okay,
and
so
Joseph Rowan. so-
continue with your questioning.
Sorry about that. So you update the spreadsheet and then it gets filed. And have you, in prior filings, noticed an issue? Are you aware that the staff allows electronic filing?
I am now, and we had some misunderstandings about the fact that you need to file something like a week in advance in order to get a case number in order to use the electronic filing, but now we're well aware of that. And I think we're actually under order now to file electronically.
You are under 20-12. We started implementing that. But in regards to your prior filings, were you reached out by commission staff in regards to setting up electronic filing procedures? Did you have staff reach out to you and suggest it?
The staff attorney, I believe, has arranged it all. I might be wrong on that. But
I meant like prior communication, like through email or such.
Yeah, Clint Alexander, our regular counsel, and I don't have, I'm not sure if it was.
The reason I'm asking is Navitas has had a history of not filing within 30 days notice, and if you are aware, Navitas's tariff requires 30 days notice to be given to the commission before the requested effective date. And I know that I've gone back to 2015, and since then Navitas has given somewhere between 19 days notice and somewhere up to 29 historically. And I know that email correspondence-wise, staff, me, has actually emailed you in regards to electronic filing procedures, and I'm kind of curious as to why that was not addressed or ever taken the next step. If you had any questions, responding back. I have given the information to, I know you had a Vanessa working for Navitas as well. I've given the information to Vanessa. I've given the information to you. I've given the information to Joseph Irwin. I have email correspondence printed out regarding the issue. I'm just wondering how it wasn't addressed or why it wasn't ever said, hey, we keep getting denied and we keep getting pushed back. Why don't we try this?
Your point is well taken. We're trying to get better. We're not a big company. We're pretty darn small, and so and frankly the FERC issue and all that has created, both in Tennessee and Kentucky, has has taken everything that we have to offer, essentially. So
just for my edification, you're not arguing that staff has not provided A continued reminder of when the due dates are, which by tariff is 30 days, and that you continue to not meet the 30-day guideline. There's no dispute there.
I don't think that's in dispute.
Okay. Well, that also indicates that there's communication back and forth between the organization and staff. So, I mean, the first point of our discussion was about whether you had the ability to communicate with staff, and apparently there's already communication going on, but somehow it's not being followed through. Or that's what it appears to me.
Well, sounds like everybody talks but me.
I don't know, Mr. Harline, we're only here to try to
Right.
determine what the situation is.
Yeah.
Well, let me ask you, I guess going forward, are you going to use Ms. Honaker as a conduit here, as an attorney to represent your interest in terms of trying to find out if there are mistakes or errors or what needs to be done in order to file it properly?
Yes, sir.
Has Mr. Hartline or Ms. Honaker been furnished with or seen a copy of your, I don't know what to call it, an errata sheet or a chart that shows all of the errors since 2015?
I can provide a copy for them.
Well, I think probably what would be best is to file a copy in the record and provide a copy to Mr. Hartline and to Ms. Honaker, and then Ms. Honaker would have a better understanding of what needed to be done in order to assist Navitas in going forward.
So, for the record also, when the commission issues orders, that gets sent to our email list under Navitas, and that's sent to Thomas Hartline, and it's also sent to, I think Navitas has its own separate email correspondence, is that correct?
I believe that's correct, yes.
So, do you receive the commission orders, correct?
I do.
All right, so can you kind of tell me how Navitas, what you do with those orders when you receive them?
File 13.
To the bird cage?
I believe the commissioners have answered aptly for me. I feel like you've asked me if I've stopped beating my wife. But in any case, I'll tell. Actually, it was here. It was here, that's right. So I'll tell this story here because it actually was here. I read the order about the unprotected, there was something I was supposed, it was a spreadsheet for the rate case. And I was supposed to turn it in unprotected. And I swear to you, I read it 6 times, and every time I read it wrong. I read it as we were supposed to turn it in protected. And I read it over and over and over and over again to make sure I was getting it right. Yet every time I read it the opposite. So part of Allison's job will be to look over my shoulder and make sure that I'm reading things correctly.
And I
Or-
won't put it in file 13.
Or just read,
Don't
or
hesitate to call if there's a problem.
or just reading things.
Thomas, if I can just interject right here, as to Sarah's question, the old saying, man proposes, God disposes. When you file a PGA application, that doesn't mean anything until you get the commission order and you've got the rates. And those rates have to go to the billing system. That's the bottom line. So I think to go back and look at past commission orders and make sure that the rates in those orders got to the billing system in a timely manner and were billed, you know, every day that they should have been billed. That's, I think the commission is gonna wanna know that, just out of a concern arising from, you know, some of the errors that seem to be continuing.
And I'd like to add to that, I noticed when you were going over the spreadsheet and you were on the cover letter, you mentioned that the rates were implemented February 1 when you were discussing case 20-12?
No, they weren't.
Or you referring, so what did you mean by that?
No, normally they would be, but in this instance,
But in, when the rates are established, is that when you start to bill them? Or when you start, you know, service rendered on and after?
our billing is on the 7th of the month.
So you start billing that rate that month?
Yes.
It's for, it's for service rendered on and after for usage of that month. So I'm afraid what you may be doing is stagnating a little bit by a month. Does it kind of make sense what I'm trying to say? The rates are for meter read on and after the date it is effective. It should be billed for usage after that point, for usage from the effective date on. I think what our concern is, and what Leah is talking about, is that we're concerned that you're not implementing the rates as they are ordered.
Too early or too late?
Too early.
Too early.
Well, and also that the rates are what was in the order, that the rates are correct as the commission approved them.
My understanding, you correct me if I'm wrong. Let's assume for argument that I turn in the file on time, which would be in the example we gave on December 31st. So I would have turned the file in on time on December 31st. You would have issued an order by January 31st, and the rates would become effective February 1st, right? Now, we bill on February 7th. Should we be billing the rate that was ordered and became effective on February 1st, or should we be billing the prior rate?
So, and you should be billing the, hang on, let me find an order example. For service rendered by Navitas on and after the effective date, requested effective date. So let's say their effective date is February 1. February 7th, you're not charging that rate. Whenever you read the meter, you kind of base it off that point and try to prorate out for its effective date. So in the GCA calculation, it's done on a quarterly basis. So the thing's gone from the screen, but you have it effective beginning certain calendar quarters, February 1, April 1, so on and so forth. Yeah, so you have it effective certain calendar quarters. But if you notice in the actual adjustment calculation, you're looking at cost for that month, and you're also looking at usage for that month. So the usage for February, March, and April. And then that's what you're supposed to be collecting. So when you bill on February 19th, or February 1, 2019, you're actually billing for January 2019 usage.
Mm-hmm.
So does that make sense?
So, if I understand correctly, if you issue an order on December 31st, and the rates are effective on February 1st, we shouldn't actually bill that rate until March 1st.
Until you get service rendered on and after February 1. So once you say to the customer, this is your usage for February, and however you want to prorate that out, when you say this is your usage for February, then you apply the rate then. When you're applying it on February 1 or February 7th as your billing cycle works, you're basically saying your usage for January, we're charging you for this rate. And that can result in retroactive rate making.
When do you actually read your meters?
Right before the 7th. So
Right
like
before
the
the
5th,
7th.
like the 5th or the 6th or the 4th or something like that.
So if you were prorating it, you could have 4 days at the new rate and however many prior days up to January 31st at the old rate. So when she says prorated, after February 1st, if you have service provided to a customer, you could bill it at the new rate. It would require extra billing on your part in order to determine however you wanted to prorate it for that split. You could take the average, the total number of usage over the days and divide it by 4 31st versus 27 31st, and that would be the split. But if you wanted to do a ratio like that or some other calculation, if I'm wrong, tell me, but I believe that's what you're saying. If whatever it is up to the date of the meter reading is, and the commission's order is how you would prorate it.
Well, that just sounds like a recipe for more problems for us. That, to a certain extent, because gas is a pass-through for us, we don't take any position on gas. It's just as well that we bill, all of it at the same rate, because whatever we charge, whatever we pay for gas, we charge for gas, and eventually it all comes out in the wash, which is what the purpose of the GCA is. So, if we slide this a month, I guess that's fine. Because we're not gonna collect any different amount of money. We're gonna collect the same amount of money regardless of when we implement the rate.
Yes.
I understand what you're saying about the timing issue, Thomas, but what I'm most concerned about is just that the rate, when it is billed, is correct. That it was in the commission order and not what you proposed.
The $6 in your example.
Oh, right. We'll figure that out.
So also, are you aware that the commission has ordered Navitas to file its future GCR rate reports in Excel spreadsheet format?
Yes.
All right, and unprotected?
Yes.
All right, I just want to make sure that you were aware. Are you also aware how many days the utility has to file a tariff once a commission order is issued? Are you aware of that amount, that time?
I'm certain that Allison is.
She is. It's 20 days for the record. There's been some issues. I've spoken to Daniel regarding Navitas's tariff, and sometimes the order is refiled into the tariff, and sometimes it's not filed at all. So I just want to make sure that the process going forward is going to be up to commission standards. So I think Allison will.
And I think I'll probably be the one filing that going forward, so.
All right. So previously you asked about using the average sales in your order or in your EGC calculation, and you said that it was required or a part of statute. Are you familiar with Navitas's tariff? The one filed with the commission regarding the GCR rate report?
I imagine you're about to tell me the tariff states a specific way to file it.
The tariff, actually, it says, quote, where the calculations require the use of volumes during a given period, and those volumes did not exist for the particular source for the entire period, or the company expects the volumes to change substantially, The company may make appropriate adjustments to calculations. Any adjustments of this type shall be described in the quarterly GCR report. So your tariff allows you to make the adjustments necessary if you feel that it's a better going forward example of your sales.
You're
But
concerned that your volatility.
yes, but you have to issue it in the cover letter. And that's some of the issues that we've had in the past, especially when case 19241 first opened. You gave us two options and then didn't really give us any information in the cover letter. So we had to issue discovery to find out what exactly was going on. So staff would really appreciate if going forward there was more explanation in the cover letter. And in regards to that, since 19241, staff has corrected the EGC to reflect, an actual sales amount repeatedly in the final order. So that has happened going forward, where staff has corrected it, but it still reverted back without explanation. Just providing background.
So if you're going to use an average, you have to let them know that you're using that average and spell out why you're using the average.
So I'm going to go back to case 19241 because it affects 19372 and the current case 20-12. And do you have a copy of that case open, or that application, the recalculated version?
What case number, Sarah? I'm sorry.
19241. I can provide you with copies if it would help.
That would be great.
Okay.
There's the number this here.
Oh, wait, Andrew. Wait. Do you have it in front of you? So, first thing I'm going to ask is, in 19241, you provided us two option scenarios, the TRA rate and then the FERC rate. And then later on August 6th, you issued a recalculated version of the FERC rate. Can you give me a quick little synopsis of why?
It's the issue I discussed with regard to the title of gas.
So you mean Spectra versus
Exactly.
Sparta?
Yeah.
That, okay. So if you will go through to the EGC page 3 of the recalculated version of 19241. Can you explain, first off, see that column that says Navitas custody gas? Can you explain the purpose of that column?
Right, so the quantity, so for instance, in the month of January, Navitas obtained 67% of the gas sold in Kentucky from the Spectra East Tennessee pipeline.
Okay. And this is just that difference, accounting for that difference. So
Right.
can I ask, why was that column added in this case and then removed in 19372?
It occurred to me, well, first of all, you didn't use this option, so since you didn't use the option, I just assumed that, okay, we're not gonna do that. Secondly, it occurred to me that so going back to the arrearage billing that they gave us. So which, originally they gave us a bill for $593,000. So, but that was determined, eventually it was determined that the actual amount was probably closer to $330,000, not $593. But that amount is actually split between amounts that were incurred between July 2017 and January 2019, and then amounts that were incurred from February 2019 going forward. And the reason for the split is because the February, at the time that they initially gave us the information, the February 2019 was still open. So we could recover that money in the regular GCA, which is why the rate case only deals with January 2019 and prior, because the GCA can handle anything subsequent to that. But since this question is open on this custody issue of gas, or this title issue of gas, essentially what I need to do is collect the full amount, have somebody tell us what the final ruling is on this custody argument, the title argument, and then if we've over collected, then we would issue a refund on that amount.
And when you say when someone tells you, who are you referring to?
Presumably FERC, I guess.
Are you planning on reaching out to FERC for a response? I know the lawyer is an issue, but do you have any future plans to get their input?
We also did hire some other attorneys to do searches on the issue. Basically, I don't know what you guys call it, but when you look back at case law and things like that, and they've not actually found anything that speak to this particular issue. We actually have this idea that maybe the appropriate thing to do is in the rate case, as part of the rate case, basically lay out that, okay, the $230 is the maximum that can be refunded, but only if we go get, but essentially the amount in dispute has to be answered by FERC, and maybe you guys can issue us an order to go to FERC, and then we can provide that order to FERC and say, hey, they've asked us, because we feel like if we go to FERC, they're not going to, they already told us to pound sand once, so they're going to tell us that again. But if you guys issue an order that says, we need this issue resolved, we think that'll carry some weight.
I just want to say that that case he's referring to is an open case with the commission in 19-430. So I don't know if we want to actually discuss issues pertaining to that here.
I think Ms. Honaker is best positioned to articulate and advance Navitas' position, or retreat from that position as somebody deems appropriate.
My only comment is, so Ms. Jankowski asked you a question as whether you had approached FERC or not, and apparently you have not because you're still making a determination. But in the responses going back and forth between these periods, you added a column, deleted a column, and apparently there's no explanation, which creates part of the confusion here, since you're doing different manipulations of what you're submitting without an explanation. It creates a lot more confusion for staff is exactly what you're trying to do, and what creates the reason why we're here today is because there's, if you looked at the page that she provided, there seems to be an ongoing either miscommunication, confusion, or whatever you want to call it. But
Right.
And you can't let the FERC thing be an open issue for staff. If you eventually have a ruling from FERC on how this is going to go, then an adjustment will be made. But we as the chairman said, Ms. Honaker, I'm sure will give you some direction, but we can't sit in a state of flux where you're kind of going back and forth with the rates. It's a position has been established at this point. That's the way we have to do the calculation. If in the future something changes, then that adjustment can be made in the rates. And you correct me if I'm wrong, but I'm pretty sure that that's the way this process works.
Right. I mean, one thing I'd like to, point out is the easiest thing in the world for us to do would be just, oh, FERC said 272, boom, there it is, call it good, don't make any of these arguments. But we want our price of gas to be as low as possible for our customers.
And from
Now,
a marketing position, you have a chicken farm that can go to propane or gas. So we understand fully
Yeah.
the reason for your low price desire. That's
Right.
nothing wrong with that.
So, anyway.
Yeah, I mean, you want to operate your business in a profitable way, but we're not involved in that. So I don't think you should rely on the Public Service Commission to take any action that's going to, that you should expect to affect how you deal with FERC or don't deal with FERC. Okay?
So, or first off, can you guys stop presenting or presenting? I think we have a dual thing going on here. So I kind of wanted to go through real fast and kind of, because there are a lot of changes that have been implemented, and it's kind of confusing as to why, because like it's been stated, there's been little to no communication. But one of the things you said was you had removed the Navitas custody column because of staff, but it was removed in case 19372, and in case the interim rate that was approved in 19241 was just solely based off the application you gave us, no corrections, no adjustments. Can you explain why you thought staff didn't take it going forward? Or didn't accept it going forward?
You didn't take this option. You took the other option.
But you also had filed this the day that we had taken the interim rate. The day we had issued the order approving the interim rate? I'm sorry.
I have a question real quick. This was a supplement that he filed later, and you're saying he filed this the day the order was issued, so you hadn't really seen this before you did the interim rate?
True, but we used the recalculated rate for the adjustments.
So you did use this?
We used it for the adjustments, correct.
Okay.
So the adjusted rate in the over collection is based off of the recalculated version. So that's why we're kind of curious as to all these little changes. So I'll go now to the actual
But
adjustment and
just- If this has this unresolved issue, though, this has this title, this custody title issue in it. So if this is what you used to calculate the
over collection.
the over collection, we don't really know if this is.
I think that harpers back to the lack of communication.
Well,
Staff
there's
was-
there's no answer to this FERC question right now. This is, I feel like big companies don't.
You haven't addressed FERC with I mean, if you're going to want FERC to answer it, it seems to me you're gonna have to hire counsel and do it. And if you're not going to do that because it's too expensive, it's just $272 and move on with it. Now, I don't see how you expect us or staff to deal with that issue when it's out there and you feel like you don't want to address it, or you want to address it, but you can't afford to. I mean, isn't that really what it is?
I think you're correct, sir.
So I'll just go quickly through some of the issues that staff has had, and if you look at the case document that was handed to you by Andrew, in the column that says why it was denied, if you notice, it was taken from actual order language where it repeatedly mentions that it was due to spreadsheet error. And for the sake of time, I'm just going to kind of go through and show all of the errors. So if you notice in the cost allocation column, with petro volume, you have all these little adjustments, less than 10%, shipped to Kentucky by Navitas. You can see up there in the formula rate where it's all adjusted. But then when you get to the actual allocation, it's a sum total of the adjustments. I don't know if that was accidental or what. I don't know what the thought process was, and the spreadsheet, it is very well made, and it goes through the entire allocation process very well. But staff has issues, and we only have 30 days notice to, approve a rate. Staff has issues when we find errors like this with no explanation. If you look at here, for the previous quarter and the current quarter has the same sales, which it shouldn't. And that's another adjustment that staff has to make. And that leads into why staff has issued DRs only asking for the spreadsheet. And there was one instance in a case where a DR wasn't responded to. And we actually had to issue another order to comply. And we need 30 days to look over this spreadsheet, how complex it is, because it has been denied on numerous occasions, more than it has been approved. And we're just trying to make the process easier going forward. You can't recollect gas costs on a one-for-one basis when your rate cannot be justified. And that's the issue as to why you mentioned before, 2012 is still open, because we can't look at the application and say, yeah, this is a justifiable rate. So, are you aware that the Commission has a template available on its website for GCA rates?
I think that's where this was all created from, was from those templates that I was originally given.
The PDF version, that's, I'll have to pull it up, but you based it off of that. I can see the similarities. It's just, there's a concern with the current application that, like I said, staff has difficulties justifying the rates proposed.
Well, I doubt that this was on the website when we originally created this spreadsheet and began using it.
I can't speak for that. Are you aware?
I mean, we started this back in
I think that
2012.
it may have been on the website, not in a very user-friendly place. If you will allow me to try to hark back to those days when you were first creating this methodology, I think what you did, and you can correct me if I'm wrong, was you also looked at the large gas utilities PGA filings, and you saw how they had their actual cost adjustments and balance adjustments set up. So, you know, there's a lot of transparency in the amount of information that's provided, and it also showed how those balancing adjustments in particular worked themselves off as monthly sales were made, which is something that, an element that you have in your format. So I think what you have is kind of a hybrid between this, this standard PGA format that I'm pretty sure all the other small gas utilities use, and the one you developed that's based on this one. It just provides a lot more information, and it actually shows the workings of the mechanism as the quarters go by. That's what I recollect happened. And because, you know, there's no PGA statute or regulation, you know, as long as the utilities comply with their tariff and the mechanism works to fairly set the expected gas cost and implement the trackers, this methodology was approved at the time.
Well, I guess to a certain extent, you and I had, I mean, we well, you were actually working with Joey Irwin, but we used this method for 6 years, 5 years, 6 years, with no issues, or
Well,
very few issues.
It works fine as long as you correctly reflect what the expected gas cost was as approved by the commission. And that is a very common error with small gas utilities, probably the one that gets corrected the most. But, you know, that line, EGC in effect during the month, that has to be what was in the commission order for it to be correct. The sales and MCF row, that has to be actual sales. You know, you could propose to the commission using something different to divide by 12-month sales, because again, what you're trying to do, like in the expected gas cost, is get the most accurate representation you can of the 12 months over which that actual adjustment is going to be collected or returned. But that sales and MCF row in pink has to be actual sales, because that's what you actually charge that expected gas cost.
Right. I think what I want to, we were able to use this successfully for at least 5 years. We've had some difficulties as we've changed some personnel. I'm blaming you for retiring. And then also this FERC issue has thrown a big monkey in the wrench here. I don't know that, I feel like you're about to go down the road of throwing the baby out with the bathwater. I don't know that I want to go down that road with you. So I think that now that we're trying to do something by hiring Allison to help the process, I have a better understanding that we can communicate more openly. I think that we should see some improvement.
And I think that's what we are ultimately hoping for. I'm not suggesting, because you have reached out to Allison and I know she's very familiar with the GCA process, I'm not saying that this whole spreadsheet needs to be redone, simplified, etc. But staff would like to see that the rates approved by the commission are then reflected in the application going forward, such to an extent where we won't have to completely dissect the spreadsheet, you know, with less than 30 days notice next time. So staff is hoping for a better reflection of those rates. And then, you know, their time allocated in your own tariff to allow us the time to make corrections and adjustments if necessary. So,
Anything further? Is there, how much?
I think we're good.
And I guess Ms. Honaker knows that the executive director is not Mr. Derwin anymore, that we can get that part corrected too.
It's only 3 late.
I think we're good.
I'm going to file with our reporter a copy of the Navitas case data, which I referred to previously as the errata sheet, so we'll have that on the record. Okay, so I guess if that's everything, Mr. Harlan, it's like everything else, I guess. There's always a risk-benefit ratio or consideration in doing anything, including hiring legal counsel. But I suspect that Ms. Honaker will prove to be beneficial and to be worth what you pay her. Because, I mean, over the last 5 years, continued problems are likely to result in an expenditure that might exceed what you'd normally pay Ms. Honaker to see that the filing over there. Okay. Anything further, Ms. Honaker? Do you have anything to say, staff? Now, this conference is now hereby adjourned.